Hey everyone, today's episode is on power of attorneys. In case you'll find this video enjoyable, don't forget to hit like, share, and subscribe. Before proceeding further, don't forget to read the disclaimer. What is a power of attorney? A power of attorney is an instrument generally created for convenience of people. In today's day and age, we have numerous business and personal transactions that keep taking place in our lives. It does not become possible or practical for any single person to attend to all of these transactions personally. Hence, the need to delegate these responsibilities arises. There are numerous challenges which make it extremely difficult for a single person to personally attend to all transactions. Some of these include travel on account of business and or pleasure, multiple transactions being carried out simultaneously, future possibility of a transaction, personal reasons, old age. Under such circumstances, it becomes imperative to have someone else act on one person's behalf, and thus comes the need of a power of attorney. Some may wonder why the name power of attorney. The reference of attorney is made in context to attorney in fact and not an attorney at law. An attorney at law refers to an advocate, and in India, only a person licensed to practice law is an advocate. Whereas a advocate in fact requires a power of attorney which is issued by any layman. Let us now understand how a power of attorney is created. Firstly, we need a person, at least one person, who will be delegating his responsibilities, powers, duties, privileges, and at least one person who will be made entitled to act on behalf of the person so delegating his or her responsibility, power, duty, or privilege. The person giving the powers is referred to as by one of many terms, being principal, donor, grantor, while the person who gets these powers is referred to as an agent, donee, grantee, attorney in fact. In India, there are many laws which deal with power of attorneys. A few major enactments are Indian Contract Act 1872, the Power of Attorney Act 1882, the Stamp Act of the relevant states, Indian Evidence Act 1872, Indian Registration Act 1908. Does a power of attorney require to be in writing? The answer generally depends on the powers being delegated. However, a thumb rule that I would personally like to follow is to have a power of attorney formally recorded in writing, duly executed by the parties involved, and registered before the office of the concerned registrar. In the state of Maharashtra, if a power of attorney has a power to register any instrument on behalf of the principal, then in such case that power of attorney is required to be registered. Article 48 of the Maharashtra Stamp Act deals with the stamp duty payable to the government for execution of such instrument, which largely depends on the types of powers being granted. In India, there are numerous types of power of attorneys, and the major types include general power of attorney, special power of attorney, and del creda power of attorney. A general power of attorney is one where the powers are wide in nature and not specific to any particular event or property. A special power of attorney, on the other hand, is a more restrictive power of attorney, which is linked with an event or a property. And finally, a del creda power of attorney is one where the agent receives a commission on account of which he is made liable to ensure any loss to the principal is made good by the agent himself. Once a power of attorney is duly made, now comes the question of how long will it be valid and how to cancel it. As far as validity is concerned, it may be noted that the power of attorney may be linked to an event and its validity would be fixed to such event. For example, a power of attorney executed until a particular transaction is complete. A power of attorney also ceases to be enforceable upon death of the principal or the agent. Apart from validity, one may want to cancel an executed power of attorney. Cancellation of a power of attorney where consideration has been received by the principal may not be as simple as cancelling one which does not involve consideration paid to the principal for grant of such powers. A power of attorney which has been registered may only be revoked by a registered cancellation document. The party desiring to revoke the power of attorney should issue a notice of his intention to the other party, followed by a public notice in two local newspapers, one in English and the other in a vernacular language of the area. This is to be followed with a registered revocation deed. That's all for now. Once again, the audience is reminded that law is a vast field and every day there are changes in the law. Nothing in this video should be construed as advice, and the viewer must seek professional legal advice from a duly licensed advocate. Facts and circumstances of each case are unique, and only a professional who has studied the same may be in a position to render legal services.